Okay, well, welcome everybody. Thank you so much for being here. I'm Joel Dodge, and I am chair of the ACS New York Lawyer Chapter. What we're doing tonight is a little bit of an experiment. It's the first time we are running part of our new series that we've conjured up here in ACS New York. And we are hoping that these conversations can take a deeper dive into a particular legal area of interest for everyone, and also to highlight for our law student chapters and potential experienced attorney career changers working in the field on these issues. We're hoping that this will showcase the great diversity of issues that our nationwide ACS network of progressive attorneys, law students, judges, scholars, advocates, and many others care deeply about and work on every day. As many of you probably know, yesterday marked the 50th anniversary of the Supreme Court's decision in Roe v. Wade. And yesterday would have marked a half century of federal legal recognition that the Constitution's guarantees of liberty and privacy protect the right to decide for oneself whether or not to carry a pregnancy to term. But of course, last June, a divided Supreme Court overturned Roe v. Wade and 50 years of precedent with it in the case Dobbs versus Jackson Women's Health. For this conversation tonight, we are joined by two attorneys who defended Roe at the Supreme Court until the very end, Jenny Ma and Hillary Schneller. They are both New York-based attorneys at the Center for Reproductive Rights, were counsel for the last abortion clinic in Mississippi, known as Jackson Women's Health Organization, in the Dobbs case and litigated at the Supreme Court. And they both also happen to be my former colleagues at the center, and it's really, really great to see you both again. We're hoping for this to be an interactive discussion. So as we talk among ourselves, please submit your own questions using the Q&A function in Zoom on the bottom of your screens. If you submit questions there, we'll monitor it and work in your questions throughout the hour during the course of the conversation. So we want you to be a part of this too. While you are thinking of the questions you'd like to ask Jenny and Hillary, I'll kick things off to just ask how you both got into this space. How did you become reproductive rights attorneys?
All right, I'll start. Hi, everyone. So I went to law school knowing I wanted to do sort of gender and sexuality law work, and had always cared about reproductive rights. It's always sort of like what made me angry. And I think that is a helpful, one of many helpful motivators for, what you might want to actually apply, right? That anger into something actually productive. And did a clinic in law school, the Gender and Sexuality Law Clinic at Columbia, which helped me actually apply sort of what I was interested in to real life, legal projects, and did a policy fellowship after law school, which I enjoyed, and got some exposure to litigation. I never thought I would do litigation. So for me, the subject matter was always something I wanted to do, but the way in which I was going to do that work has changed a lot. So after a policy fellowship, I was able to get a litigation fellowship here at the center in 2014, and they have kept me around those 8 years, and it's been amazing to be able to work with our clients, many of whom are abortion providers, and sort of do the sort of big picture strategic thinking and concrete sort of application of reproductive rights law on behalf of our clients. So that's my shorter. Jenny's story is probably much longer, but that's my sort of short version of my path here.
Well, I laud Hillary for knowing what she wanted to do. I think I kind of was in the opposite space where I knew I wanted to litigate, and certainly for you law students out there, right? Law school is so geared towards litigation. It's like case law driven. So I knew I wanted to do that. I actually never thought I would do reproductive rights litigation, and perhaps I just did not anticipate perhaps this day coming. And I thought, well, other smart people can certainly like defend and litigate these cases. I had a very circuitous route to repro rights, but also to law school. So for folks who are not sure about what they are going to do, like have no fear, because I think that if you follow your heart and like what you want, you actually can be a very happy lawyer. So I came to law school about like 8 years out of undergrad, so very late, did not go straight through, to say the least. Had a former career then in law school. I clerked for a few federal judges. I worked at law firms. And then in 2016, I thought that reproductive rights was really something that was going to be at risk. I did not know that it would happen so quickly, but I knew that I wanted to use my litigation skills to work on these issues. And so that's how I came to the center. And remarkably, that's like 6 years ago. It feels in some ways longer and in some ways much shorter, but truly, as Hillary said, and as we'll get into more, I could not be more happy in many ways about the work that I do and the kind of impact that I have and who we represent, and the kind of long-term thinking and short-term thinking that we're doing, even in light of everything that's happened in this space in the last 7 months.
Great. So you've both wound up at the center, taking your own different routes. For those of us who don't know, could you just say a little bit more about the work that the center does and what its mission entails?
I'll give the short version, and if there's more. So the Center for Reproductive Rights, for those folks who might not be as well acclimated, is a global organization. So Hillary and I work in the US litigation department, but we actually litigate and work on policy and represent folks all across the world. And the belief and the mission of the center is that reproductive rights are human rights. And I think it's really interesting, at least sitting from my perspective, to see where the United States is right now with regards to reproductive rights as in comparison to the rest of the globe. And I think working in an organization that has that multifaceted, looking at the global perspective has been really key to thinking about rebuilding the jurisprudence in this area.
Yeah, I mean, I think that that's a great summary of the center's work. And just to maybe add on a little bit, being able to look at what our colleagues work in Latin America, where there has been forward movement on improving, decriminalizing and improving access to abortion, right? The United States is now moving backward, and we can learn from what our colleagues are doing across the world in our work to rebuild the right, and not just rebuild Roe, right, but to make a better and more robust right to reproductive autonomy that addresses abortion, contraception, maternal health, again, all issues the center works on in the United States and across the world.
So yesterday, as we mentioned, was Roe's 50th anniversary, and it was the first Roe Day without Roe. I'm just wondering, like, what you each did to mark the day, and just how it felt to be an attorney working in reproductive rights on that particular day.
So I can start, and I was talking to Jenny about this earlier today. So I was working on a case that we will be filing later this week. So in a way that was apt to be working on behalf of our clients who are still trying to keep access to abortion available to folks in states where it's legal, and to serve folks in states who may be traveling from the, about 12 states where abortion is now illegal. So that is how I kind of marked the day. It's not that different than how I might have marked the day had Roe not been overruled, but I think to me that was, not much of a choice to use the day that way, but an appropriate way to use to sort of mark that would-be anniversary.
Yeah, and perhaps I put more import into such things as anniversaries, but it felt very bittersweet to me. It, as we'll get into, for such a long-standing right to have been part of, what my career and what the legal jurisprudence and kind of the rule of law has stood for 49 years and X amount of months. It was the first kind of marker, and seeing what effect, our providers, the community, people across this country have gone through in the last 6 to 7 months, and then what they will go through. So it was a very kind of difficult marker. On top of that, as some folks who celebrate know, it was Lunar New Year, the mark of Lunar New Year yesterday, and to wake up to the horrible news about the shooting in Monterey Park, I think in some ways there's kind of a I don't want to say it's a synonymous, but it also helps you understand that many things can exist at the same time, right? You can have many feelings about the Roe decision itself, the anniversary, your feelings surrounding it. You can be, experiencing grief, but also looking ahead to what might be better and what one can imagine. So I think I had a lot of different feelings, and then, frankly, coupled off at the end of the night with a lot of food.
Thanks, Jenny. So we should definitely talk about looking ahead and making things better. But I think first we need to start by talking about Dobbs. And Hillary, you were litigating Dobbs from the very beginning, back when it was with Judge Reeves and where the Constitution was actually being correctly interpreted. Could you just tell us about Dobbs and really go as far back as you want to in your explanation and tour of that case and how we got to today?
Sure. So in 2015, Mississippi passed a 15-week ban that it knew was unconstitutional. It was not the only state that did that. There were about a dozen other states that followed sort of between 2019 and 2021 that passed bans on abortion at literally every stage of pregnancy, from a total ban up through 22 weeks, including states that passed bans at 6 weeks, 8 weeks, 10 weeks. So literally throwing numbers at the wall, because the point was to ban abortion, not to find a way to, reach a middle ground. It was to ban abortion however and whenever the states could. In each of those cases, including the Mississippi case, courts blocked the bans because they were clearly unconstitutional. They banned abortion before viability, which is the standard that the court set in Roe and reaffirmed in 1992 in Casey, and had been reaffirmed and reaffirmed time and again since. In Judge Reeves' decision on the 15-week ban, when it was before him, he noted this was an intentional attempt to provoke the Supreme Court to overrule Roe. The Fifth Circuit, which is not a circuit that has often been one that we win in front of, agreed with Judge Reeves, struck the ban down, just emphasizing how easy this case was, given how clear the Supreme Court had been that states cannot ban abortion before viability. Individuals have the right to make the decision whether to continue their pregnancy before that point. The state asked the Supreme Court in around June 2022 or May 2022. This is where my numbers, because the pandemic, get really confused because time has no meaning. But in any event, the spring of 2020, the state asked the Supreme Court to grant cert to take the case, and did not really ask the court to overrule Roe. They said there is some way for you to uphold Roe and Casey and also uphold our ban, which was never the case, but that was what they presented to the court. Justice Ginsburg then passed away, and Justice Barrett was her replacement. Over the course of a year, the court circulated the petition for cert many, many, many times. And in May of 2021, am I getting this wrong? I feel like I'm getting my numbers wrong. In any event, in May 2020, the court granted cert. May 2020? May 2022. Oh my God. I really apologize. Time has no meaning. May 2022. The court granted cert, and the state's brief came in about a month later saying, absolutely eviscerate, completely overrule Roe and Casey, and took an incredibly aggressive approach, in part because the composition of the court had changed. That is the only thing that changed between their cert petition and their briefing. So, that is not super surprising to us. It was the whole point of passing a ban on abortion before viability, was to get a case before the Supreme Court. So I'm happy to talk about sort of what the court's decision then was, and then the way it sort of really radically changed the way the court had been interpreting the liberty protection for abortion. But that is the road of how we got to Dobbs.
And I just want to add one thing that Hillary said, but to amplify it. When you ask the Supreme Court, as many appellate practitioners probably know on the webinar, when you are asking for a fundamental change in the law, you should put that question very forthright, so that the justices, when they decide whether or not to take that question up on cert, should know, right? So the formulation of this question should be, not only about abortion and viability, but whether or not Planned Parenthood versus Casey and Roe versus Wade still are good law. That was absolutely not the way that the question presented was given. I urge you guys to go back and look at the papers. The actual cert petition had the ask, and as Hillary said, lots of other reasons why the court could rule with Mississippi and uphold their 15-week ban, but it was really buried in a footnote, and that footnote then ended up being the entirety of the merits brief. So I do think that's really important for lawyers, advocates to know and to remember as part of the history of how we got to this day and how the Supreme Court ruled in Dobbs.
Yeah, thank you for that overview. If folks want to hear more about the reasoning in the opinion, we can go into that, just ask in the Q&A. But for now, let's just talk about outcomes. I think most Americans understand that the case was about the constitutional right to abortion, but Dobbs actually has broader ramifications than that. So can you explain to us why the court's decision in Dobbs was so significant?
Do you want to start? So I guess I'll say,
and I'll just say, Hillary and I did discuss this a little bit, and we said we could spend probably hours on this topic alone, but we'll give you a very truncated version.
I'll say maybe two things. So first, it was the first time the U.S. Supreme Court has taken away recognition of a fundamental right. And I think that alone, right, is seismic. It's not that the court, grants us what our sort of inherent human rights are, but it matters that the court recognized that the Constitution guaranteed people's right to make fundamental decisions about their bodies and lives, and now says, no, your liberty does not include that fundamental right. And did so without, right, explaining really what had changed or any real reason other than we disagree with the courts that decided Roe and Casey. The other piece, which I think has ramifications for other rights that the court has recognized, is Justice Alito's reasoning in the majority opinion. He says that we look to decide whether the Liberty Clause or substantive due process protections reach certain rights by looking to whether the 14th Amendment, at the time the 14th Amendment was ratified in 1868, whether there were affirmative protections for these rights. So that's how he would analyze the right to contraception, right? The right to marry someone of a different race or of the same sex, the right to consensual same-sex activity, all rights the court has protected in various cases over the years, and that were not affirmatively protected at the time the 14th Amendment was ratified. And there's a good reason for that, right? The people who ratified the 14th Amendment were white male landowners who would not have thought that other folks really have fundamental rights to liberty that extend in those ways. And the 14th Amendment was meant to reach forward, right? It was part of the Reconstruction Amendments that were meant to repair the brutal ravages of slavery, including violations of bodily integrity, family separation, etc., and to ignore sort of the important reasons why the 14th Amendment was ratified, even by, right, those white male landowners, is to kind of fundamentally miss the point of the 14th Amendment and freeze the Constitution's protections in 1868, when most of the folks, right, probably on this webinar didn't have fundamental rights to vote or participate sort of in society. So that is one of the most radical parts of the decision that I think will absolutely have ramifications well beyond abortion. I think we're already seeing some of that happen in the States.
Yeah, I mean, and again, we can continue to talk about this, and everything one person probably says will trigger and elicit why the decision is so significant. But I will also add, right, this is a decision that has stood the test of time. So whatever individual feelings on a personal level, or the justice's personal level about their feelings on abortion, Roe is a landmark decision. It's the kind of decision that if you go walk on the street in America, and ask them, well, can you name a single Supreme Court decision? They would know that case and what it stood for. There were many cases in between, including most notably Planned Parenthood versus Casey, but others, where the building up of the jurisprudence on this topic was steadfast. There was no argument that Mississippi had presented in their papers that had not been tackled by the court 25 years earlier, and soundly rejected when you read the Casey decision, I urge you all to do so, even though maybe Hillary disagrees, is really this tension that you feel amongst the justices in that trifecta, kind of fighting with perhaps their personal proclivities, but what is necessary for jurisprudence, what is necessary for the legitimacy of the court, what is necessary for our system of rule of law. And to me, as someone who's now read Casey so many times, that's that was what was so disturbing, was how easy in some ways that could be flipped. And then, as Joel and Hillary know very well, we just had so much support outside of the record, and there wasn't a robust record here, right? Because obviously it's not like you needed to go to trial or anything. It was just very simple on the law. But so much of various fields had grown or even been engendered because of Roe and the protections that the protection of abortion as a constitutional right. So we actually had evidence in our amicus briefs from economists who weighed in on the first time about the empirical impact of the right to abortion and what that could do in American life and family life. We had sociologists weigh in. We had the American Medical Association weigh in. We had every major organization, and most notably, because I think folks who have deeply read the Dobbs decision will know Justice Alito's history and tradition points, right? And we had historians weigh in. And I think fundamentally, even to the most kind of rudimentary, logical thinking, it is impossible to think that abortion did not exist in our American history and tradition. And certainly, I think it depends on which text you're looking at when you make those determinations. And if you look at what the American Historical Society had weighed in on, and other historians who came in on the side of Jackson Women's Health Organization, you'll see that clearly abortion was very much in the fabric of American life, early American life, continue to do so, and will continue, right, despite anything that the Supreme Court or what Curtin Dobbs says.
Yeah, I think both of those points that you two just discussed are really powerfully illustrated in the joint dissent in Dobbs from Justices Breyer, Sotomayor, and Kagan, which, if you haven't read it, take the time to read that. It's ferocious and unrelenting, and really nicely articulates this really deep conflict between two very different visions of what a constitution actually is, right? So you have like the Dobbs majority that would freeze the Constitution in time in the 1860s and sort of like incorporate all of the biases and blind spots and prejudices of that day and carry them forward. And then you have the dissenters who think, no, the Constitution should really evolve with the times and keep up, like apply those values to today's problems. And it's just the fact that that frozen Constitution is winning out is really concerning for both the rights that will go unprotected, but also kind of like the relevance of the Constitution going forward, right? It feels unsustainable. I don't know, what do you two, I know a dissent is cold comfort, right? But I just wonder, like, what do you two draw from that very like no holds barred and uniquely mournful dissenting opinion that we got in Dobbs?
Well, I mean, in one way, it's sort of like, okay, well, someone was, or three someones heard us. And I mean, the amicus briefs that Jenny mentioned really are like chock full of the actual impact that we explained to the court overruling Roe would have and has had. And so the court can't say, no one told us. And the dissent, right, captures a lot of that. And sort of also indicates the court is, the dissenters are saying, not only is this going to have a traumatic impact on the country and folks seeking abortion care and folks accessing any kind of pregnancy care, but also like, what does it mean for the court? And we as an institution are sort of undermining our own integrity in a way that will, right, not stop at this case. So again, I think mostly for me, it was like, okay, someone heard us, and that is important, even if it is not the side that carries the day.
Yeah, and I'll say, I mean, and for folks who haven't read Dobbs or haven't read the dissent, a notable thing is that it's not like each of the dissenting justices wrote for themselves, which could have been an option. They wrote together, and it was not authored by anyone who was named. So the three dissenting justices came in, and I think that also, to me, and maybe I'm reading too much into this, but felt kind of like the Casey, the three justices in Casey as well. And there was like a mirroring aspect to that. I also think dissents are the kind of jurisprudence to build upon for future courts. And certainly having read every single abortion decision that was before the High Court in sequence, in preparation for our case in Dobbs, you can see how that jurisprudence builds. Most notably, I'll say Justice O'Connor's notion of undue burden, which had been in many, many cases in her dissents, in her concurrences, right, leading up to Casey, and that's where you see it come to fruition. And I don't think that courts are the answer to everything. I hope for a day when we can rebuild in jurisprudence that's better than Casey and Roe. But I also know that while those cases stood, how much of an impact on millions and millions of Americans those protections had, and also just kind of seeing what it is now, how much and how many millions of people have lost access. So I hope, as we think about what building jurisprudence looks like, that dissent and many others to come, because I think we're in a world of dissents for a while if you care about reproductive rights issues or similar issues, that we take that seriously. In some ways, the justices are giving us avenues to think creatively and to think ahead. So that's the mandate that I take from it. And I know that, right, again, many folks have been working for half a century and more, building upon dissents to get to the place where abortion was overturned. And that's good kind of resilience that I think lawyers who support reproductive rights, people who do, need to have.
Thank you both. So we'll move past Dobbs in a second, but one last kind of question or topic I wanted to bring up around the case itself. I think it's fair to say that Dobbs did a number on the court's image and legitimacy for a bunch of reasons, including that the court kind of tipped its hands, I think twice really during the course of that case, once involuntarily with the leaked opinion, which others can discuss. I don't know if you have anything to add there, but I think maybe more interestingly was the Texas case that went up to the court while Dobbs is basically being decided. And this is the Texas SB8 bounty hunter extreme law, that there's no way that should be constitutional, but the court let it stand and sort of gave an early preview that it was going to overturn Roe and essentially shut down abortion more or less in Texas months before it formally overturned Roe. I was wondering if you two could just talk about that. Like, what was that like? What did you make of the SB8 decision while you're awaiting the final word on the merits in Dobbs?
I mean, the fact that the court let SB8 go into effect on September 1st, I think was our first preview of what was going to happen, and was a preview also of what we've now seen sort of across the country, right? Shutting down abortion in the second largest state in the country showed us a small picture that, and now the harm there that we saw there has been absolutely magnified so much. As you know, half the states have moved to ban abortion, and it's illegal in about a dozen. I mean, right, the center was litigating both of these cases at the same time, and they're unconstitutional for the same reasons, plus the additional, though, tweak that Texas made to try to evade judicial review, right? To say any random person can enforce our ban on abortion. It's not the state. So we're going to try to successfully sort of get around the court's review. And I mean, just the fact that the court couldn't find its way around that, I think is, you know, just gave an obvious preview for what was going to happen. I mean, I will just say also, though, like, as one of the litigators working on the Mississippi case, right, we're still litigating to win that case, even if, as Texas was happening, right, the likelihood was less and less. It was more and more clear we were going to lose in Mississippi, but you have to be able to try to continue to put your best arguments out there to advocate on behalf of your clients, even as the court is putting out a decision that is, you know, showing their true self. So I don't know if that exactly answers your question, but I think doing those two things at the same time, and also in the midst of a pandemic when the court is letting states ban abortion, I mean, there were many layers we were having to kind of contend with. And again, not just us, right? Our clients are having to go through this while trying to see patients coming from Texas because they can't get abortion there. You know, a couple other states passed these vigilante bans after Texas, and those took effect. So just the kind of chaos that was already brewing, you know, made the whole thing sort of even more unfair and cruel to have to contend with.
Yeah, I'll just amplify. I mean, just thinking back to those times, and for anyone who wants to do this work, it was just very chaotic. We knew that Mississippi had asked the Supreme Court, right, to take cert, and they had agreed. Right after the early aughts of the pandemic in March 2020, states rushed to ban abortion then, right? So I would argue actually like SB8 was one indicator, but they like really used a public health emergency in order to, first thing they wanted to do was to make sure that abortion was banned. And so my colleagues and I, Hillary and I, would just kind of, I will personally say, speaking for myself, I was not able to process the pandemic at all until many months later, because it was just furious litigation for everyone in our team to try to keep the doors open for our clients. And not only that, but they had so shifted their practice to a degree of thinking, and this is maybe very micro level, but like where the chairs were, right, as we were kind of learning about what the science was. And remember, like PPE was very sparse, so it was a question of who gets to access PPE, and it was just a crazy time. And then just moving ahead to seeing amongst all of that, the SBA case move forward, and the fact that Texas would even, have this vigilante law in the books. I think the treatment that the justices gave to our colleague Mark Herron, who did an amazing job on such short notice, right? That case was on hyper speed. And I would say that listening to the oral argument, and we were outside because we couldn't go into the court at the time because of the pandemic, I thought the argument went very, very well. And we would come out of that argument with a win. But certainly that didn't happen. And I think that to me gave a very, very strong indication of where the court might be in the Dobbs case. And I just, the human toll on attorneys, to the extent that it matters. I remember sitting at my computer at 1 a.m, because that would be midnight Texas time, September 1st, right? Just waiting for the court to act and just having that feeling of like, surely they're going to do something, right? Like, and then like 12:59 happens. And it's just like, I think the emotional toll on that, just to know that they would unleash so much cruelty on the second most populous state in this country is just, it was very difficult to process then. And to some degree, I guess, made it more, I mean, we always knew, right, like overturning Roe was a possibility. And as Hillary said, like the test cases that were coming through the courts, but it made it all the more real that this court would not potentially blink to unleash the kind of harm that it did in the Dobbs decision.
See, this is why I have no like 2020 to 2022. It's all just like a big blur of timeline. So
Forgive us on the timing.
Yeah, no, just me. You seem to know what day it is.
Well, tell us more about the harms after Dobbs, in the days and weeks after for your clients and on the ground on through today. Like what is the impact been?
This one, why don't you start?
Yeah, I mean, I would say it's immeasurable. I mean, as Hillary said, there's over a dozen states that have banned abortion now. There is projected to be about 24 states that will eventually ban abortion or likely to. And this is despite court cases, despite every like possible initiative, legal, to try to prevent this kind of harm from happening. And it's what we had predicted. We had told the court this in our papers on Dobbs, and amicus brief certainly supported this, but the harm is vast. I will say that on a personal level, right after Dobbs, and perhaps the theme is it's difficult for us to process everything because just obviously the Friday that decision came down, I think we had been anticipating that it would probably occur the next week and possibly the next Friday. But it came down one Friday before, at least I personally thought it would. And, there was a series of events that happened after decision, of course. But that evening, many of us started working on the trigger ban cases. And for folks who don't know, these are laws that are in effect in about those dozen states I mentioned that will spring forth if Roe were overturned in whole or in part. And many of us here at the center, as well as our other litigating partners, sprung immediately in and filed cases. I personally filed a lawsuit in Louisiana, the team, and it was just that weekend. Another theme of non-processing, just like sleeping for 4 hours over that entire weekend, getting papers ready to go into court and seeking a temporary restraining order on that Monday and getting a preliminary injunction that lasted for over a month to keep access available. And just the notion right away at that time to try to mitigate harm as much as possible, that every single day that a clinic was open. Lives were being changed. People were able to fashion their lives the way that they wanted to, and their families. And it just breaks my heart because our clients, many have shuttered their healthcare facilities. Some that are able to have thought about relocating, but that's not for everyone. They are still getting calls every single day from people desperately needing healthcare in which their states have denied them that care. We are hearing much more about obstetrical emergencies that are happening across this country in states that have banned abortion. And that means, right, like you would present in emergency rooms, and sometimes these laws are so vague and confusing and come with such deep penalties that doctors and frankly their legal departments are not allowing and turning away people who are presenting with emergencies rather than providing that care. We're talking about folks, right, crossing state borders. We're talking about people who simply, once they made the decision to terminate their pregnancy, unable to get care in so many states. And this is affecting millions of people. I forget the actual number, but in the 7 months and stubs, like the harm is, in my view, like immeasurable, but will only increase exponentially as the years go by. And so it's really hard. I mean, from a level of speaking with folks who see this every day, for representing them, for fighting for this fight of exactly the kind of harm that we told, the court that would be unleashed in this country.
Yeah, I'll just add that, sort of picking up on that last point, that the chaos and the uncertainty and the harm is the point, right? The court knew and still overruled Roe. And right, to be clear, Roe was not enough to guarantee equal and robust access to abortion across the country. People on low incomes, people of color, people in rural areas, other marginalized communities never really got the full promise of Roe. But it did provide an important federal floor and some measure of access for some people. And ripping that out really has unleashed, again, as Jenny was saying, really immeasurable harm. And there's one thing Justice Alito said in the majority opinion, and one thing Justice Kavanaugh said that I think are sort of important to keep in mind here. One, Justice Alito said overruling Roe will bring certainty, and will just allow the states to handle this, and will get the court out of sort of dealing with abortion issues, which
was a major theme in Mississippi's briefing, right, as well.
This will solve everything. This case, if you rule with us, that's the end. And that is obviously not true. I mean, in the weeks after Dobbs came down, we filed over, collectively, probably over a dozen cases were filed. The laws are really unclear, deliberately so. And right, even if the state says, oh no, a provider can, treat someone with a miscarriage, no one's really given enough certainty to do that. And the uncertainty has a chilling effect, just in the way Texas SB 8 has had a chilling effect on providers. And the other piece is Justice Kavanaugh's concurrence. One of the points he made is a point he made at oral argument as well, that overruling Roe is neutral. And again, it echoes sort of this will just let each state decide, but it is fundamentally not neutral, right? To say a state can decide that someone is going to be forced to continue a pregnancy and go through childbirth, especially in a country with a maternal health crisis where it is 14 times more dangerous to continue a pregnancy and give birth than it is to have an abortion. And that number is much higher in the states with the most abortion restrictions. In Mississippi, it is 75 times more dangerous to continue a pregnancy and give birth. And that number is even higher for people of color. So it's just, again, we can talk about this forever, but just the inaccuracies or sort of deliberate misleadings of the majority opinion and the concurrences, I think we are just seeing played out on real people's lives in a way that's just
Yeah.
really cruel and hard to put into words, but
Yeah, just to humanize that impact, like if there's a woman in Mississippi, which is now has banned abortion and is surrounded by states that have banned abortion, essentially. If there's a woman in Mississippi who needs to have an abortion, like what is her best route now? Like what do people do who are in that position? And many, of course, are not getting care because they just are blocked from access. But like how far does someone have to travel? Like what are the hurdles they now have to overcome because of Dobbs?
so people with means may try to leave the state to access abortion care in maybe Illinois or maybe Florida, although note Florida has a 15-week ban in effect right now, right? So access has been constrained, even if not completely banned in a lot of states, sort of across the South and Midwest. But a lot of folks don't have the means to make that travel, right? We heard even before Dobbs that, right, having a car that's good enough, having gas money, et cetera, to get to a clinic that was nearest to you, having time off of work, not being fired from your shift job because you don't have paid leave to make an appointment at a clinic, arranging for childcare, all of these things can mean someone doesn't get to a clinic that's even close to them. So traveling hours and hundreds of miles out of state is absolutely out of reach for many people. And again, even if you're able to do that, making all of those arrangements can be incredibly, incredibly challenging.
Yeah, and I think that if you think about even before Dobbs, before Roe was overturned, how difficult it was for so many people to access abortion care in their state or neighboring states. Now, if you just look at various maps, right, it's not about even finding the provider in your state. And that's really quite difficult with the misinformation that exists in a lot of states that have banned or severely restricted abortion. But on top of that now, it's not just how can I make it from Mississippi to Alabama or Mississippi to Texas, but you have to go across abortion deserts, multiple state lines, if you are able to access care. And sometimes even when you reach a state, there's existing restrictions because it's not like all of a sudden abortion was restricted because of Dobbs, right? We've been, abortion has been like the main, like so many bills, hundreds of bills have been attempted at states year after year and have been just compounding and mounting and multiplying even before this past year. And so when you finally reach a state, you understand that like, oh, you have to now understand the laws of that state. There might be a 2-trip requirement. There might be like certain mandatory reporting requirements, certain like unnecessary medical tests that require you to stay there, right? And when you couple that with the situation that people find themselves, it is really, truly prohibitive. And I do want to emphasize one additional point, because if you really look at the states that have banned abortion care, to highlight what Hillary said, these are the same states that have some of the worst maternal mortality rates in this country, the worst infant mortality rates in this country, to the point where they have it held as a crisis. And the US, as folks probably know, does not rank overall nationally well in this, but if you really kind of look down at each state level, so it is, I mean, to me, just amplifying a public health crisis that exists here in this country, and will only kind of compound it, make it worse. And I think forcing someone to remain pregnant against their will is absolutely the way that we should be talking about this, right? I think this kind of choice-based language from before, it's not like someone's choice. It is the government that is trying to force you to stay pregnant and to fashion your life in a way. And that's truly, if not, right, it is truly against liberty. Like, I think putting law aside, it just feels like it's against your liberty and your bodily autonomy. Like, even if those words are meaningless for you outside of casebooks. So that's very cruel. And then one more thing, right, to state the obvious, pregnancy is not a static condition. And the longer you stay pregnant, right? And you're thinking about that person that Joel is describing, who's like trying to figure it out with like perhaps existing children, balancing a job that doesn't give you time off, and where you have to decide like whether or not you're going to make like rent or food on your table, right? Like this is like the real life of what our providers go through, what Americans go through who are trying to access this care. And on top of that, like, right, as a pregnancy like continues, I mean, once you've made that decision, the thing that you would want for that person, if you are truly, pro-life, is to provide care to them as soon as possible. But unfortunately, that's not where we find ourselves in about half the states.
So let's turn to picking up the pieces of the damage the Supreme Court has caused. And I'm going to kind of combine a number of questions we actually have in the Q&A from folks about sort of other means, other levers of power that can be used to restore reproductive rights to some extent in the absence of Roe, whether that is popular referenda in states or legislation or state constitutional litigation, or even kind of like popular mobilization in the streets among the people. What role do you see all of that playing in restoring Roe? As Karen, who is joining us, put it quite succinctly, what are the next steps legally and outside the courts to regain ground on reproductive rights?
So all of the above. I think that's true, right? It's state legislation, federal legislation, organizing, people just talking about abortion, state courts, state constitutions, and ballot measures. And we can talk a little bit about each of those, right? We saw just this past election, pro-abortion rights measures pass and anti-abortion rights measures fail in California, Kentucky, Montana, Kansas. I may be forgetting a couple, but I think there were 6 in total, and that's huge. Michigan, sorry, that's a really important one. That's huge, and right, not necessarily in states people would expect an abortion rights measure to pass or an anti-abortion rights measure to fail. And I think that shows, right, when abortion rights are actually something people can vote for or against, they vote for them. And, again, people's fundamental rights should not be up for a popular vote, but when they are, we know the American public wants people to be able to make these decisions for themselves and not have the government make those decisions. I will note, and we can talk about each of these, but, we are absolutely in a very state by state strategy mode right now, in part because the federal courts are quite hostile. So we're helping with state ballot measures, state legislation, going to state courts and arguing that state constitutions guarantee these rights. But it won't work in every state, right? And not every state has a ballot measure process to change their constitution or guarantee the right to abortion. We should use that strategy where it exists, but it will be a slower and patchwork strategy, which, again, not to undermine that's important, but it's going to take time and a lot of energy and effort from all of those different sectors sort of complementing each other. But I can talk about state courts and state constitutions, or you want to talk about federal?
I'll talk a little bit about the general thing, and then we can maybe go back to the states. I think that 2 things really give me a lot of kind of hope in this, right? The first is what Hillary mentioned with the ballot initiatives, but what that translates to is that abortion is really popular. Like, just believe it and know it. And now there's even more proof and growing. We know that no matter how many times you ask a question, polling for abortion is not only majority, but a full majority, right? 7 out of 10 Americans usually. And that was before Dobbs and only growing after. So know that you're in very good company when you do all of the above things. And that means whether or not you're a lawyer who wants to be in this space or otherwise, like there are so many things you can do to amplify that public response. because I'm not saying like the courts are necessarily per se influenced by the public, but I think that is a factor. I also think that, right, lawmakers certainly are, right? You are their boss on, like, tell them how you feel about this issue. Whether that's through marches, whether that's through calls. I think normalizing the fact that abortion has always been, but is increasingly popular, is very important. And that is kind of the core of any rebuild of anything. And just to kind of push on Joel on rebuilding Roe, I think that we can imagine more. And certainly when, right, Roe was a compromise in and of itself. And for those of you who are lawyers, like, definitely think creatively. Like, we are 7 months in, and it's devastating. And you've heard from Hillary and I, who like talk to folks, and you may know people who have experienced, you know, some of the things that we've talked about today. But this fight is going to last more than the next 7 months. That part I can totally guarantee. I don't know how long it will be. I mean, just speaking for myself, I don't think it's 50 years, because see Exhibit A on the popularity point, right? It just will take a lot of all of us in our various strengths that we bring, in order to reconstruct and reimagine and build upon, for whatever that looks like, right? And whether that means like, right, reconstructing a floor in which we like can dream about something better, where reproductive autonomy is truly the way that we get to live our lives in this country, regardless of what any court says, or we have like some limited court protections and rebuild on that. I also would say, right, like everything is temporal. Again, on the 7-month piece, and nothing, right, is for like, it just is not the cadence of justice, right? Doesn't look just like this. It kind of is a zigzag, and we're in kind of a dip in repro, but maybe this is how I continue to do the work that I do. I really don't believe that that is going to be permanent. I really think that we just need to continue to do what we've been doing, try to keep up the drumbeat. It is hard. It's hard to be in it every day, but I'm sure also hard for you all, right, to do so. But that's just going to be integral to caring about this. And frankly, like, and unfortunately, I just think there will be more and more stories that are told. And I'm not sure what combination of the right quote unquote story like will change hearts and minds, but I've already seen a lot of changes, right? Even, I mean, frankly, like on the heels of times I was walking up the subway and someone, like this couple were talking, and they're like, oh, did you hear about the Supreme Court, what they did? And I just really have not seen those types of conversations maybe coming out of it. Yeah.
Maybe just to give a little, you know, more, a couple of concrete examples, because I think, you know, there are two facets of sort of building better and more robust right to reproductive autonomy. One is that it's about more than abortion, right? It is really learning from reproductive justice advocates that it is about the right to decide if, when, and how to become pregnant, be a parent, and to be able to parent your children safely and, you know, with dignity. So being able to, as litigators, right, litigate cases around each of those facets of a broader right to make decisions about our bodies, lives, and how we construct our families and how we raise our families. I was on a different sort of webinar conversation the other day and pointed out that we're seeing certain folks make arguments about the right to parent, right, in banning critical race theory in schools, and, you know, attacking access to gender affirming care for trans kids. And that is sort of capturing this right to parent argument in a really nefarious way. But we are able to say, no, individuals have the right to make decisions about their families that support, right, you know, their own vision for their families, and not sort of cede that to the other side in a way that really undermines people's sort of individual dignity and equality. And sort of the second point I was going to say, if the first is sort of beyond abortion, is sort of beyond liberty, right? Roe was very grounded in due process and the right to privacy and the right to liberty. But I mean, even the 14th Amendment has other clauses like equality and the right to life. And many state constitutions have, inherent rights provisions, right to health provisions that I think provide a lot of opportunity for creativity and for us to argue that state courts should recognize that those provisions protect the right to abortion and, again, broader rights to make decisions about pregnancy, birth, and family.
And I'll just add on the federal piece. I mean, certainly, right, if you support reproductive rights, if you believe in bodily autonomy, then let the people that represent you know this. And I mean that on a very local level. And it does matter, even if you feel or know that your representative already is supportive of these issues, to let them know just how many of their constituents care about this issue. So that's a very tangible, easy thing to do. Whoever your representative is, and I know we have people from across the country, right? Like to just do that. I routinely call my congressperson in Brooklyn, New York, who I'm pretty sure is supportive of these issues, that to know that one of their constituents deeply cares and wants consistent votes on like issues that I care about, right? And to go to an earlier point, you vote for these people, they work for you, so make them work for you. Similarly, right, on the executive level, I think we have seen this administration say various things about protecting reproductive rights, and I think that is really important to have the like that be held accountable and to say like, look, again, kind of going back to the public point through voting, but also through like expressing what you care about, find right the federal legislation that would protect the right to abortion, and express your like support for these issues. I think that is just absolutely important to even rebuild and create like the floor that we need to continue our work.
That was a very inspiring and hopeful kind of dialogue. That felt good to hear. Yeah, I mean, Jenny, you were talking about the kind of like that we're in a temporary moment, like in the long sweep. Dobbs may not necessarily last forever. It does seem like one takeaway from Dobbs itself is that the Supreme Court has actually lowered the bar for overturning its own decisions, right? Like that's the lack of credence it gave and the short shrift it gave to stare decisis and Dobbs could someday be used against Dobbs itself. Essentially, you need numbers on the court plus some dissents and critical public commentary to cite to, and you can ultimately change the course of the court's jurisprudence. So I think that's important for all of us to keep in mind as attorneys who care about these issues. So what are the biggest legal battles that we're going to see, that we're already seeing around abortion in the wake of Dobbs? I mean, it seems like a couple that have already crept up are cross-state travel issues and also more issues around medication abortion. So I was wondering if you could talk about those.
Yeah, I'll start. So I'll add one additional thing. So a federal ban on abortion is a possibility as well. And I think that that's very significant to think about, that there could actually be legislation that would make abortion just banned across the country. I think crossing state lines has been in the ether for a while, and you see it in Justice Kavanaugh's concurrence as well in the Dobbs decision, where as more people are crossing state lines to access this care, there is pushback from certain state legislatures that are trying to prevent people or planning to prevent people from accessing care. So again, cruelty on cruelty in some ways. So I think that is an area that will be tested. Another area is medication abortion, Joel, as you mentioned. Medication abortion has become increasingly popular over the years and now accounts for 54% of abortions in this country. And I think the kind of anti-abortion movement's objective was never to stop at overturning Roe. That was an objective. And there will be more and more extreme measures to try to get to the ultimate goal of banning abortion nationwide. And so this is really important for people who live where we're situated here in New York, but also California and Illinois and places that seemingly have states that support reproductive rights, that there's this incredible push and various methods similar to what Hillary was describing in terms of various test cases to kind of push the seams of the contours of the law to see what might be acceptable. And I'll just highlight one case in particular that it was filed recently, right before Thanksgiving. And it's a case filed in federal court in Texas called Alliance for Hippocratic Medicine versus the FDA. And this is a lawsuit in which various anti-abortion organizations and doctors have sued the FDA for mifepristone, which is the first drug of a medication in abortion, which was approved by the FDA in 2000. So 23 years of safety and efficacy record, right? And 5 million people who have accessed this drug and used it. And despite all of that, and despite the medicine and evidence that was in place then, and now obviously has only increased, they are challenging that initial approval and seeking to take it off the market totally. So I use that as one example, as just, again, I think part and parcel of the kind of cases that were developed at the time of when Dobbs came up. As Hillary mentioned, Mississippi was not the only state that was planning to ban abortion and had attempted to do so in order to move that case up through the courts. But I think this Alliance case is one that folks who are court watchers, who care about the rule of law, right, who care about the ability, right, to, if you really take this, that facts like medicine, I think it's really significant. And I'll just say, putting abortion aside, it is a very concerning lawsuit because the kind of allegations made in this complaint not only go at the kind of rule of law concepts that we've talked about today, but would have very detrimental effects across this country on how the FDA, which is entrusted and is the agency that's supposed to approve drugs, oversee food and drugs, right? That's literally in their name, would be able to approve new drugs, would be able to oversee new research and development, and how patients across this country would access any FDA approved medication. So I just say this to kind of say, like, abortion sometimes to us feels like the testing ground for a lot of like new notions. I don't even want to say novel, because I think it's more like testing grounds to see how far and how extreme certain theories can pick up wind.
Yeah, I could just add that on the big legal fights, I mean, Jenny was talking about federal fights and medication abortion, just to pick up on something we both were mentioning earlier about state courts. So the center has been litigating in the state courts since our founding 30 years ago, and we have continued to do that. And now that will sort of ramp up even more. And just earlier in January, in a case we are litigating with Planned Parenthood, the South Carolina Supreme Court agreed that the South Carolina Constitution guarantees the right to abortion in striking down a 6-week ban in South Carolina, which was amazing, and may not have been a court we would think would recognize that right.
And the first court to issue a decision after Dobbs on what their state constitution, on the merits. Yeah.
On the flip side, that same day, the Supreme Court in Idaho came to the opposite conclusion. So, this is again kind of getting another way in which we're going to see a patchwork of what the legal status of abortion is across the country, which again is sort of why building back a federal right and federal legislation like the Women's Health Protection Act would guarantee statutory rights to abortion and, even the playing field for folks across the country, because these kinds of rights absolutely should not depend on where you live.
Yeah, one question that someone raised about new legal tactics is whether there is a positive religious liberty claim to be made, basically defending abortion access on religious grounds, including by suits filed in Florida, in Missouri by progressive rabbis. Do you see much promise or path to success for those?
We will have to see. We have seen sort of, I think, two kinds of arguments being made. One from a more sort of free exercise perspective, that banning abortion infringes on a person's right to decide, right, when life begins, and how to kind of control their lives and make decisions based on their religious and moral beliefs. And the other is more of an establishment clause argument that by banning abortion, the state is establishing a particular perspective on when life begins, and right, that people who can become pregnant must and should stay pregnant, right, which is grounded often in sex stereotypes that have been used to keep women unequal for many decades and centuries. So I don't think any of those cases have gotten to a merits decision yet, but we're obviously following them and seeing. I think we're going to see a lot of sort of creative arguments, again, maybe not totally new arguments, but once a federal floor of protection, the sort of easiest argument out there is not as easily available, and there is more variety and diversity of arguments people can and should be making to try to rebuild the right.
Yeah, and I'll just add, just on alternative arguments, I think for years, it's not like we were not attempting to provide courts with alternative arguments and other means in which to strike down various restrictions and bans. I think that courts, in some ways, right, of course, you would go to whatever the federal jurisprudence is, and so never really touch upon the alternative argument that was argued or briefed. And I mean, to me, as we think about, right, like what comes ahead and some of these creative arguments that are given, it does allow also to the adjudicator and for us to present these arguments and possibly for them to also be accepted to a court now that that federal floor no longer exists.
All right, well, we are just about at time, but I wanted to wrap up by asking you about action steps, engagement for people in the audience. We actually have a question from Olivia. She's an OBGYN physician based in Hawaii and wants to know what she can do to become more involved in this work, as it so intimately affects patients as well as the way she practices medicine. So what can physicians do? What can attorneys do, law students, and just like regular everyday citizens do on these issues going forward?
Well, I hope Olivia joins any amicus briefs for OBGYNs that are presented, because I think that is a tangible way, and to be plugged into doctors who are supportive of reproductive rights, and to keep abreast of all the things that are going on, because as we kind of alluded to, right, science and medicine, among many other disciplines, are on our side, and we will continue to need. Law is one aspect of this, right? The public is one aspect, but we're going to need actually specializations, and medicine is a huge part. So please email me if you want to continue the conversation, Olivia, and I'll give you specifics. But overall, and I know we're speaking to a largely legal audience, right? I think things we mentioned, like holding your lawmakers accountable, making sure they understand your positionality, whether that's through calls, whether that's through marches, whether that's through your vote. I think for law students and alumni of law schools, demand reproductive rights be taught in various law schools. I think that is a huge actually area that gets one class in con law before these times. And frankly, I think you could do an entire year on, we often joked actually on the SBA case that like you could actually teach an entire class on just that case alone and all the happenings that occurred. So I think it is absolutely imperative to get this area taught in law school so that we have future practitioners who are already armed with a lot of kind of knowledge and substantive, just kind of be able to hit the ground running when they're working on these issues. I think if you can and have the means, support abortion funds and organizations that are providing care. It is a very, very difficult time right now, even in places where abortion is generally accessible, just what Joel had mentioned, right? Because of patients coming across state lines, the congestion that it's created, the backlog of people being able to access care, it is very important. And 75% of abortion patients are low income or having difficulty making ends meet. And it's like the pivotal way for them to be able to access care in this consistently receding landscape. And I would say, you know, one of the main things is just resilience. I think we've talked about the fact that this is not a next 7-month fight. It's going to be a semi-year fight. And I'll just say, like, just because Justice Sotomayor, just to echo what she said at the ACS conference, and I have it quoted, right? You know, we really don't have a choice because, quote, I lick my wounds for a while, sometimes I cry, and then I say, okay, let's fight. If it doesn't kill me, it only makes me stronger. And that is what adversity does for you.
Well, I can't do better than Jenny Ma and Justice Sotomayor, so I will let Justice Sotomayor have the last word on that front.
Yeah, we're gonna give Justice Sotomayor the last word. Well, thank you both for the work that you do every day and for spending the time with us. This has been a really great discussion. It was both informative and I think also inspiring and constructive and really clarifying about how we can do better and improve upon the wreckage that the Supreme Court has left for us. So thank you for bringing that to ACS. Just as a reminder, everyone, ACS is a 501c3 organization. We do not endorse candidates or legislation, but be sure to stay in touch with ACS and our New York Lawyer chapter. You can sign up for our emails at acslaw.org. Find us on Facebook and follow us on Twitter as well. We have lots of good programs coming out all the time, so stay in touch. But thank you for being with us tonight. Enjoy the rest of your evening and please stay in touch with us.